Welcome to When Family Matters Become Legal Matters.
Hey, everybody. Welcome to an all new episode of When Family Matters Become Legal Matters, where we help you navigate the legal steps needed to protect your family, your future, and your legacy. I'm your host, Mike Leon. I'm joined here by Betsy Holton, the founder of Holton Law Group, who has years of experience guiding families through estate planning, elder law, and special needs planning. And Betsy's here to share the practical advice and trusted strategies that turn complicated legal issues into peace of mind for you and your family. So, Betsy, let's get into this. Let's talk about these blended families and estate planning and how people can avoid conflict and ensure clarity. Let me ask you at the top, what are the most common estate planning challenges that show up in blended families?
Well, thanks, Mike. Good morning, and thank you so much for having me. We have to even sometimes just define exactly what a blended family is, right? And that's usually how you come up with why there are some complications. So, unfortunately, this is no longer the Leave It to Beaver society. And we don't have mom, dad, and the 2.5 kids. Of course, I never understood where they got the 0.5 kid from, but that's not what we have anymore. And so a lot of times we have individuals who have either remarried or they just happen to have children who are outside of the marriage. As a result of that, you have children who the biological parents are not the husband and the wife. And there are also other situations where we have blended families. We can have blended families because children are staying with grandparents or other relatives or any situation like that. So we have instances in society now where we have families that do not fit into the way that the laws that are on the book were written for families to exist. And so we have to have ways to make sure that we're taking care of those families. And a lot of times it's going to generally be a second marriage. So we may have some children from the first marriage, or like I stated earlier, outside of the marriage, and then new children within the marriage. And so we want to make sure that there are provisions put in place so that make sure that everyone is taken care of. And so, of course, we want to have the sit down and the conversation with the family so that it is planned out in a way that can avoid conflict and hurt feelings further down the line. Right.
Yeah, well, and it's a perfect segue because I want to ask you, how can someone protect children from a previous marriage while they're still providing for a current spouse?
Right, right. And a lot of times this is exactly what happens. So you get married and then you have this new set of children, or even if you don't have children, but you have a second wife. If you do not properly plan, most states have what we call an intestate succession plan, which is basically the state's will that they write for you, right? And that will and that plan will more than likely make sure that the spouse of the person who passes away ends up receiving most of the assets. Well, if you have adult children or children outside of that marriage, if you don't plan for them, they aren't taken care of. A lot of times you have to make additional plans because you may be in your second marriage or you may just have these other children who are older. So there are more different rather provisions for minor children than there are for your children who happen to be adults in most of these intestate succession plans. So you don't want to leave that to the state because you could very well end up allowing the new spouse to receive all of your assets and your children receive nothing. That is generally not the way most people would have that.
I don't I don't think they would. So let me ask you, just in your experience, what are some examples of how poor planning in these blended families has caused conflict? Like how could those situations have been avoided?
Right, right. So, unfortunately, what I see so often, um, dad remarries. We have older children who are not even raised in the home. So it's one situation where we have the children that are all raised in the home, but even if they are, these older children are completely left out of the situation. And when dad passes without a will, the wife literally, in a lot of situations, receives all of the assets. She receives the home. She receives the assets in whatever joint. Well, obviously, if there's a joint account, she would automatically receive it. But if dad had his own account separate, but listed her and didn't list her as a beneficiary, it's quite possible that she would also receive all of those assets, and there's nothing available to take care of them. What I also see happen a lot of times is that the younger children who need more care and uh, asset protection, so to speak. We need to. It's a lot harder to take care of a minor than it is to take care of someone who is an adult and can take care of themselves. If we don't make the proper plan and we don't put something in place to make sure that those children are cared for, then it could be a situation where only the adult children are receiving assets. And a lot of times that happens when someone did at least try to make a plan, but they didn't keep up the plan, right? So a lot of times we run into situations where people do not remove the first spouse from some of their beneficiary designations. That has happened a lot, and I don't quite understand how one goes about doing that, because when I'm done, I'm done, and I'm going to make sure I go through and take you off of everything. But yes, it has happened that the prior spouse is still listed as beneficiary on documents. And so remember, you've made a contract with this financial institution that is holding money for you, and so they're going to abide by their contract. And in your contract, you've listed someone as a beneficiary, so they're going to pay out to that beneficiary. And so those things completely avoid your estate. So it's so important that you not only put a plan together that's going to mirror the wishes that you have in your head. You want to put it on in writing, but you also want to update your plan every so often. We typically suggest every 3 to 5 years you sit back down with whomever you wrote your plan with and review it, because these very things could happen. You can become divorced, you can remarry, you can have new children. And if you have not made provisions for them, they can very well be left out.
Always got to update those plans. Speaking in that same vein with respect to structure and planning, how can a trust, or can a trust, help with that structure and clarity when there are just so many, maybe stepchildren, second spouses, multiple generations involved?
Absolutely. That is one of the most amazing things that I have learned in assisting my families in putting together a plan that works for them when they need it. There are a couple of things that a trust does. Number one, it completely removes it from that intestate succession that we discussed earlier. You are in charge of making the plan and giving the direction as to what is to happen with your assets. Another beautiful thing about the trust is before you pass away, if you happen to become incapacitated, you have language in your trust that tells everyone who can help or assist make decisions for you, right? Because we tend to end up in court more for those types of situations than we even do sometimes in a death situation through a probate process. But when we're dealing with guardianship and incapacity, having different individuals with different levels of connection to you makes it very difficult for the court to determine who is the best person to be in that role, managing your assets and your person, right? And
Right.
so if you've taken the time to go through, because once your family's blended, you may find that your spouse's son is much more responsible, much more level-headed, not quite as emotional as your daughter is. And even though she may be your biological daughter, he may be the better person to take on that responsibility, because it is a very important responsibility, but it does need to be one that comes without emotion. Okay. And so when you have a blended family, sometimes that is absolutely the best choice is to have the other person. But if they're not biologically related to you, it makes it more difficult for a court to make the decision that that person may be the best person for you.
Betsy, we've been talking about the planning part of this. I want to stick on the communication part of this because why is open communication so critical in these kinds of estate plans, and how can someone like you, a lawyer, facilitate that?
Yeah. So what one of the things, and this is not just with my blended families, this was every family that comes to me for advice and assistance in putting together their plan. It is of utmost importance that you sit down with the individuals that will be responsible for taking over if your plan needs to be put in action. You don't want to make decisions assuming that someone A wants the responsibility to take on the task that you put before them, or B has the capacity to do it in a way that is not led by emotions and causing a lot of conflict. So having that conversation opens the door, and it's a tough conversation, don't get me wrong. No one wants to talk about death. No one wants to talk about what happens if I'm not able to take care of myself. It's not a conversation that you want to have, but it is such an important conversation that you need to have to make sure that people are able to avoid conflict and that the process can move as smoothly as possible.
It's well said. People always try to avoid it, but unfortunately, death is unavoidable, right? In these situations, are there, Betsy? Are there specific documents or clauses that maybe help prevent these misunderstandings between these heirs?
Yes. So one of the things that we've already spoken about is the trust document. Typically, families will put together a living trust, a revocable living trust, and what you would put into that trust are successor trustees. And so these are the people who will step up and take over managing the trust, either the assets or, if necessary, other parts of your life and things that are related to the trust. We also prepare documents such as a durable power of attorney. A lot of people refer to it as a financial power of attorney because it's the document that kind of helps manage the money. This is the one that you can take to the electric company and say, Dad is not able to take care of his bill. I need to be able to come in and pay his bill for him. So I have this power of attorney. You don't need to go and pull out the whole trust document. We also prepare durable or medical power of attorneys or medical designation of healthcare surrogates, depending on your state. And that document is the one that says to your medical providers, I'm the person that dad wants to have conversations with you, help make decisions about his health care, help make decisions about where he's going to receive treatment, help make decisions about the types of treatment and the types of physicians that we want to assist with his medical care. There's also a separate document that we like to prepare. And in today's very litigious, everyone wants to sue everyone society, it's very important to also have HIPAA authorizations in place. Because what the HIPAA authorization does that's a little separate than that healthcare surrogate is it allows for other family members to have direct conversations with the medical providers. For instance, we've all played the telephone game. We know that if we start a conversation and we tell person number one that this is the diagnosis, prognosis, and potential outcome, by the time it gets down to person number five or six, okay, there's some brand new medical condition that no one's ever heard of. I mean, we know that the story could just be completely different. So here's an opportunity to preemptively allow your family members to have that conversation. And I can tell you, not only through my planning, but dealing with other professionals, dealing with medical professionals who happen to either be friends of mine or that I've just come in contact with, as well as through the litigation process, the doctors are becoming more and more concerned about having these documents in place. And if they don't have these documents, they are not willing to assist the family. That is a lot of additional stress that falls on the family, because if the third or fourth child down the line can't have a conversation, we have different levels of comprehension. So, even if the first person told them exactly what the doctor said, they're not in a position to go and ask additional questions so that they can meet them, the doctor can meet them at their level of comprehension, right? Because the other family member is not a medical provider. They don't know how to provide extra information to help them understand exactly what's going on. But if they have the opportunity to speak with the doctors themselves, so that they have that clear understanding within themselves as to what is going on with their loved one, then you have a much better situation to deal with.
Well, Betsy, let's try to relieve some of that stress here. So, for blended families out there who are watching this, listening to this, they haven't created a plan yet. What's the first step that they should take?
That first step is what we talked about, sitting down and having a conversation. Because there are some families where the children being blended doesn't matter. Everybody's made a decision that, as far as we're concerned, your kids are my kids are your kids. If something happens, everything gets split right away, evenly. But that's not what's going to happen if you don't put your plan together. So you have to have the conversation first about how you want to make that division. If that division is not as simple as that, then it also needs to be a conversation ahead of time to kind of explain what your thought process is as to why you may want to make different provisions for different children. If you have the conversation with them ahead of time, imagine the level of discomfort and grief that has been avoided when something happens to you and they find out at the last minute. If everyone's expecting to get everything split equally, and then you find out, oh, now we're the stepchildren, that's tough, and that's not something that you want to have happen. And so we also can make plans. Once we have that conversation and we sit down together to put the plan together, we can make plans that will segregate funds for children, leave them in trust, or uh, make plans so that minor children are not put in a situation where they have to receive money outright and then have to go through another court process called guardianship, so that someone is taking care of those assets because they're minors. And that would segregate those funds away from whatever you would provide to the spouse. So there are a host of ways, but it starts with that first conversation, then sitting down with a legal professional, making an inventory. I cannot tell you how important it is for people to sit down and make an inventory, because we get to a point where we find out, oh, there's this other asset no one knew about.
Mm-hmm.
Right? And so we may end up having to go through an additional level of a probate process because we didn't know about it. So we make the inventory and we make a decision as to how we think would be the best way to distribute.
Well, Betsy, thank you so much for the insights and analysis on all of this. Truly appreciate it.
Yes, it's been my pleasure.
And thanks everybody out there for listening to When Family Matters Become Legal Matters. If today's conversation is helpful to you, do me a favor, be sure to subscribe, leave a review, share the show with someone who might need it. And if you want to connect with Betsy and the team over at Holton Law Group, visit holtonlawgroupfl.com. If you're in Texas, DFW, the letters DFW, trustandwills.com. Your family's future is too important to leave to chance. The right plan can help make all the difference. I'm your host, Mike Leon. Thanks for watching, everybody.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.